Brian, Thom, for people who are listening to this and reading this, we know that there is concern around private land and fee simple land, and concerns around whether or not it can be taken away from them. Without asking you for legal advice, what would you say to people?
I'm an anthropologist,
there you
so
go,
I can't
exactly.
give you legal advice.
Yeah. What would you say to people based on your depth of research? What would you say to people who say, I'm worried?
I mean, first of all, I think it's fair and not entirely unexpected at all that our Attorney General appealed this right away. We really do need in Canada the Supreme Court of Canada to make a final determination about the relationship between Aboriginal title and fee simple title. We know, for instance, in Australia, when all of that worked out after years of native title claims there, that any time a fee simple title, private property is created, it extinguishes the native title. So does that work the same way in Canada? We've never had a court make a ruling on that. We actually don't know. We don't know if, in fact, the Indigenous title might be an underlying title on top of which the fee simple title is a burden. And so Indigenous communities maybe have some sort of decision making or land use planning authorities that give rise from that underlying title. All of those things are legal unknowns. And so this decision opens the door for the higher courts to consider the deep legal traditions in Canada and to work out what that relationship is. I think in the short term, nobody's going to lose their homes or anything like that. I think the judge was pretty clear in the decision. She said, I demand that the governments approach Indigenous communities in negotiations in good faith with the honor of the Crown in their mind to reconcile these two issues, the Aboriginal title and the fee simple title issue. So the courts are even saying, governments, you can't just say private land's off the table. You just need to go negotiate it. And I think that's going to, for people like Robert Morales, who've been waiting for 20 years to have a negotiation over the fee simple issue because it's been illegal, unknown in Canada, this will provide at least a framework for that discussion to happen.
Last question to you, Brian. We appreciate your time. The province of the Musqueam Nation said we already know they plan to appeal. Where do you think what does this say about inter-tribal, inter-First Nations negotiations in BC?
Yeah, well, I think it says a lot about our adversarial court system. I think, within the communities, families have these connections, but when we're drawn into an adversarial court system where, issues of exclusivity are paramount, you're led down a kind of, an all or nothing discussion. I think that what Cowichan nations did here when they filed this claim, they looked for a very specific finding a title at a very specific footprint in their old village site. And Musqueam, in their 1976 declaration, which they've stuck to like glue ever since, it's a broad territorial declaration that includes Tlactinas. And so the difference between spot title and territorial title is significant. So we're going to find out if this declaration just creates a hole in Musqueam's title or if it pushes back their boundary, or whatever. So certainly the courts are going to be, changing Musqueam's future on that one way or the other.